Hello, everybody. This is Mike Sullivan and Eric Wames, and we are here to give you our presentation on Dynamex and AB5. This is a hot topic. Things are changing in workers' comp and employment law land, and we want to get ahead of it and fill everybody in on what exactly is going on and what it means. Hi, Eric.
Good morning, everybody. Eric DeWam, employment law managing attorney. Today is an important presentation, not just because to keep updated on AB5, but because it's a moving target.
Yeah.
So what we're talking about today, even though we'd like it to be set, law that we're giving you is going to probably change, and it could change today, it could change in a month. Because of that, we're going to be updating you as it changes. But today, it's important to just get our hands around Borello and Dynamex and where it is currently.
Yeah, it's a big deal. First, let me introduce myself and Eric. So I'm Mike Sullivan. I'm the principal of Michael Sullivan and Associates, and I guess we're a big law firm now. I think 75
Pretty
lawyers,
size.
9 offices doing workers' comp defense primarily, although we use civil employment and immigration law now too. I'm also the author of Sullivan on Comp, which if you're listening to this, you might be a Sullivan on Comp subscriber. Sullivan on Comp is a comprehensive treatise which covers all of workers' comp law. And, it's used ubiquitously throughout the state of California. Everyone has it. We have like 6,000 subscribers. And today I'm putting on my Sullivan on Comp hat and not my defense attorney hat, because when I talk from the Sullivan on Comp perspective, I really try to take a broad-based view, a neutral perspective, and flesh out all the issues and all the perspectives. But Eric is going to be an evil defense attorney, right, Eric?
Yeah, well, I'll try to minimize my cynical, salty defense attorney perspective, but no promises. And the reality is I won't be able to. But.
Well, yeah, we need to hear from the employer's perspective, because really it's the employers who are mostly up against it here. There are implications, of course, for workers on the other side, but the employers are the ones who really need to educate themselves right now as to what's going on. So there's Eric Wames. He is the managing partner of our employment law section here at Michael Sullivan and Associates. And let's go here. Okay, so the plan, what we're going to do today is we're going to lay it all out for you, first of all, because in the beginning there's a test for determining independent contractor versus employment status, and that's a big deal. And they had the Borello test forever. We had the Borello test.
Over 3 decades.
Right. Yep. So we'll explain that to you. Then we'll talk about the Dynamex decision, which just came out. I think it's a 2019 decision, actually, right?
It's 18. Yep.
18?
Mm-hmm.
Oh, yeah. Wow. Time flies when you're getting old. Yep. And it changed the Borello test. Supreme Court changed his mind. And then, of course, there was this law, AB5, which passed. And it made Dynamex codify with a lot of exceptions. So we're going to run through it all, and then we're going to talk in depth about the exposure to businesses, the opportunities or difficulties for employers, and try and flush out the implications of these changes and provide some guidance as to actions that could be taken, whether you're an employer, TPA, insurer, or a worker. What actions or thought processes need to be changed now in order to adapt to these significant changes. Why is this a big deal? Why is it a big deal? I mean, why do we care?
Well, it depends on where the perspective you're coming from. Now, coming from the salty defense attorney's perspective, thinking about the employers, the impact is grave, because employers that have been historically categorizing people as independent contractors, where Borello was a more liberal standard and a balancing test, now the ABC test makes it pretty clear, and it's designed to where employers are typically going to fail it, and they're going to be employees.
Right.
That's the design of the ABC test.
So, I mean, if I'm an employer, I want everybody to be an independent. It's gone through the mind of every employer, I think, at one point. I'll make everybody an independent contractor. Yep. Because then I don't have to pay them benefits. I don't have to pay matching taxes, all this. So,
exactly.
So, when you can get away with it, you would make them an independent contractor. But now this really restricts the ability to do that and reclassifies employees all over the place.
It does. And the problem is it may change for many employers in California the entire business model that they're working under. Yeah. For example, the gig economy, the Ubers, the Lyfts, the DoorDash, and also, we're going to be talking about it towards the end, the truck driving industry, motor carriers. It's a huge impact. And and it changes everything. But for all employers, if you're ever considering having an independent contractor or you have them already, you have to understand where we are now, because if you get it wrong, there's the labor code penalties are real. You get back wages if these are actually supposed to be employees, overtime, meal rest break violations, tax consequences. I mean, the list goes on. And this is what creates the infamous, and I'm a trial attorney, and these are the types of cases that I deal with, are class action and PAGA claims. And the PAGA claims are the trend in California because you don't have all of the requirements, the stringent requirements.
Public agency claims.
Yeah, it's the Private Attorney General Act, and I'm sorry, but it basically vests employees with an attorney general capacity to sue their employer on behalf of themselves and everyone else. So it's kind of a mini class action, and it provides for attorney's fees if they win. These are the trends in employment law and wage and hour claims that plaintiffs' attorneys are filing, and this will be hitting the courts. It is already, and we'll talk about that later. But this is going to be the big issue hitting the California courts and exposing employers.
And it's a big deal too in workers' comp. We'll get into it a little bit later, but the Division of Industrial Relations, they've allocated significant budget resources to compensate for what they see as, a greatly increased amount of workers' comp claims, because I think there's just more workers. And so this means that the workers' comp community has to brace itself for a whole new set of claims. At least that's what's anticipated. So it's.
And I think that's a real concern because, and we were talking beforehand a little bit about it, but the reality is, even though there's a slight delay we'll talk about for getting your workers' comp in order for if they're employees, the people who want to be independent contractors, if they get injured in the gig economy, an Uber Lyft driver, are going to want to now be employees if there's a car accident or some type of injury.
Yeah.
And those claims are going to skyrocket.
Yeah.
They're going to skyrocket.
Okay, well, let's get into it. I've just been handed a note that says I'm to remind the users that they can download slides in the handout section of the interface. And, if you're a Sullivan on Comp subscriber, this will go into our data bank of webinars. We got a ton of webinars that we've been doing for many years, and it's all accredited, and so you'll be able to get it there. But also the firm will be making it available to the world in general. It's kind of an unusual situation. Usually we do Sullivan on Comp webinars is just for the subscribers. In this case, though, the firm was allowed to, by Sullivan on Comp, to use it because it's important that the whole world know about it as quickly as possible. Anyway, okay, I'm going to run through the history of the law to give context to make sure everyone listening understands the fundamentals.
We need to know where we were before we can know where we're going to go.
Yeah, so in the beginning, there were independent contractors versus employees, right? So the employees have basic rights. Independent contractors just don't have them. Minimum wage, unemployment insurance, paid sick leave, paid family leave. Independent contractors, not so much, actually not at all, right?
Yep.
And independent contractors are not allowed to get workers' comp. If they have a claim, they don't get workers' comp. So this is the fundamental distinction. And then we had Borrello, and that came out in 1989, and it gave a test. The Supreme Court gave a test for determining whether someone was an employee or an independent contractor. And there's a presumption of employment status, but there's all these different 11 things that I have listed here on the slide that say whether you have to consider all these things in the aggregate, right? You have to look at all the factors and make a judgment as to, of course, that's a mess, right? So it means every single case is, every single case is got to be considered, and all kinds of, it's really hard. It results in a lot of litigation. But the most important factor was the right to control work. If the employer had the right to control your work, you generally were an employee. If they couldn't, then you may not be. But I have a list. I guess I'll read them down. Well, I guess I won't read them down. There's too many of them. There's 11 of them. Some of them are whether you're holding out to be a business for yourself, whether there's a bargaining over the contract to complete the work, whether you're supplying your own tools or instrumentalities, whether you can hire employees on your own, if there's a particular skill, what the parties intended when they contracted. That's just some of them, but there was a lot. And that was a Borrello test, and it was existing in workers' comp land, and I assume in wage and hour land for a long time.
This was for employment law the test, both for workers' comp and for any employment law issue to determine if somebody was an employee.
Yeah.
And what employers were doing, because this is there's 11 factors, it's not, you have to meet all of them, it's a balancing test. And then case law came after Borrello and really said, hey, the emphasis is really about control. It's about control. Are you giving them tools? What does it really look like? Do they have another job? Are they working for you 40 hours a week? And there's no way they could probably, have another job. And employers were, if they were on the fence on this balancing act, would lean towards independent contractor because, as you said, the overhead difference was massive. So and a lot of employers were, and why we got to Dynamex, were abusing that and misclassifying people, which is why we ended up getting to Dynamex eventually.
Yeah, and then came Dynamex, right? So Dynamex came out in 2018, okay? And it was the Supreme Court, and they said, we changed our minds. So much for stare decisis, right? Sorry, if you're lawyers out there. If you're not a lawyer, what that means is that the courts are always supposed to be consistent. That's why we always look to precedent. This is the idea behind the laws. It doesn't just change. The Supreme Court can do that. They can say, we changed our minds. And so they did.
And they did.
So what happened was there's this Dynamex, which is the same day courier delivery service, like FedEx or UPS. And prior to 2004, the drivers were considered employees. But then someone got a big idea at Dynamex, said, let's make them all independent contractors. And like I said, employers want to do that, and we'll save some bucks. And they did. They made all the drivers independent contractors. And then the employees didn't like it. So they filed the class action against Dynamex, alleging it misclassified as delivery drivers as independent contractors. And the parties started arguing over what legal standards should be used. And up it goes to the California Supreme Court, shooting down Borrello. And they said, no, we're changing the standard. The multi-factor test in Borrello no longer works. They said, look, this isn't a functional test. It has disadvantages in both the wage and hour context and workers' comp, and it provides a lot of opportunity for manipulation. The court is concerned with protecting the worker here. They're saying, look, we don't like employers taking advantages of the ambiguity of Borrello and how hard it is to show that you're an employee, and we're going to change the test. And they did. Yep. They changed the test.
They changed it, and what happened here was not the whole workforce wanted the change. It was just one or two employees that filed this case that ended up getting to the Dynamex Supreme Court case. And what the Supreme Court did, although it said Borrello was not applicable here, it did limit it to what are called the IWC orders, the Industrial Welfare Commission wage orders. And what those are, there's 17 of them in California, and most every occupation is categorized under one of these wage orders. So they limited it at this point to the IWC orders, but for other purposes, there was still an open question to the extent Borrello still applied.
Yeah, so here was the ABC test, and I have a couple of examples from my life that I like to use in order to flesh it out. You tell me if I'm doing it wrong here.
I like it.
So they said an worker is going to be considered an independent contractor only if the hiring entity establishes three things. So the employer has to establish all three things, and if they can't establish one of the things, then they're an employee. Okay, so I like to think of the housekeeper who comes to my house, and she cleans it for me because I, as a single male, have no ability to do anything. Okay, so I need help badly. I'm just walking around in circles. It's not good. So here she comes. So the first prong is the worker has to be free from the control and direction of the hirer in connection with the performance of the work, both under the contract or performance of such work and in fact. So Bertha comes to my house, and I definitely am not giving her control and direction. I mean, I might tell her, you forgot about this or do that, but she knows what she's doing. I don't really know what she's doing, and she does it. So I meet the test A. I meet the first one. I don't have control and direction.
A, check.
Yeah, check. Okay, so the worker performs work that is out. This is the second one, the second prong. The worker performs work that is outside the usual course of the hiring entity's business. Yes, yes, because my business is doing stuff like this, right? Running a law
Yep.
firm, writing a book.
B,
She does not do that. She cleans the houses. So she performs work that's outside the usual course of my business. So B, I check.
check.
And then the worker customarily is engaged in an independently established trade, occupation, or business of the same nature. This is what they do. They do something different than what the employer does. So they're customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed for the hiring entity. Yes, yes,
Well,
because she does a different job than I do.
well, no. So in C, the question would be, is she just working for you?
Right,
Or does she have does she have her own business? Is this
right.
a housekeeping business? Is this Mary Maids,
Okay.
where they have other customers, other clients? Or is she somebody who lives with you, has room and board, she cleans there all the time, and she's there, 5 days a week? If that were the case, C fails.
Right. So she was just coming to my house only, and she she's like a live-in maid or something like that. It wouldn't work. She doesn't have her own business.
She is your employee.
Yeah.
She is your employee. Yeah. You failed C, and automatically she is an employee for you.
But I didn't. My house isn't that big, so I'm in good shape.
Okay. So C check. Bertha, if you're listening.
Bear with me because I'm going to give another example to show when it doesn't work. Okay. So I have a lawyer who works for the firm as an independent contractor. He's of counsel, and we give him work, and he works with the firm, but he does the files and submits the bills, and then he gets a piece of the bill, right? Okay, so he's of counsel, he's an independent contractor, he's not on the payroll. So is he free from the control and direction of me? Yeah, he's doing the work. I'm not telling him what to do in the case. He's a good lawyer. I'm supervising him. Uh-oh, you got a problem here, Ian. I'm supervising him. Sorry, folks. We are not going to update the computer at this time. We'll postpone it more than 10 minutes, make it an hour or something. Yeah. So anyway, so here comes the of counsel, and he is under my supervision, so that's questionable, right? And then door number 2, is he customarily engaged in the occupation? Just click it down, make it remind me in an hour and say postpone. I won't let you click it. Then drag it away from the screen. Okay, see how it works. Thank you. Sorry about that, folks. Little TV issue came up on our thing. But anyway, so then he performs work that is outside the usual course of the hiring entity's business. Yep. Nope. No, he doesn't. He does law just like I do, right? And then C, he's customarily engaged in an independently established trade. Now he may work for other firms.
Yep, and that's
so he may pass C, he may pass A, but he doesn't pass B.
Right. Yeah. So and see if he has other firms he works for, other clients, and the problem with C that comes up is, well, how do we know? How do we know that he, as the employer, how do we know that he is working elsewhere? And it puts the onerous on the employer to ask the question. Sorry,
word?
Was that too? Okay.
No, it's onus.
Thank you. Honest, thank you. On the employer to
onerous is what it's like to talk to me.
Agreed. So C, it puts it on the employer to figure out, are you really working somewhere else? You have to ask the question, and arguably you have to actually ask them to sign a document that says, hey, I'm working elsewhere, I have other businesses.
You want to paper your file.
You want to paper it, because if in both 85 and here, it is unclear who is required to prove C.
Yeah, well, so it's pretty much on the employer. If you're a responsible business, it'd be on you anyway. But sometimes you want to turn a blind eye and say, oh, I didn't see I had nothing to see here. I wasn't there. It was somebody else. I was drunk at the time, right?
Yep.
And I didn't know. But they're not going to put up with willful blindness, is what you're saying.
That's true.
Yeah, okay. So there's a presumption that people are employees. It permits workers to be classified as independent contractors only if the hiring business demonstrates that they satisfy all 3. Okay, so what do we think about this? Well, it was more favorable to workers depending on your perspective as a worker. I mean, we were talking earlier about how some workers probably want to stay independent contractors, but in the eyes of the Supreme Court, it's more favorable to workers because they have more access to benefits that employers are working to get rid of. So no single, under Borrello is like all these factors, it's all over the place, and they have to discuss and weigh and judge. You just don't do that here. They have to meet all 3, otherwise it doesn't work.
And as we discussed, it's really set up so the employer in that test is going to fail the test.
Right.
And and the reality is 90% of the workers in California are going to end up being employees, not independent contractors.
Yeah, there's not going to be hardly any independent contractors left. You really have to have a separate business doing a separate thing.
Yep.
Right. And do it the way you want to do it. That's what they're saying. And that's nobody except a truly independent business. Right. So you can't, this a big shift. Right. Okay. Well, Dynamex repeatedly emphasized that it only applied to ICW wage orders. So we had this weird situation where under the employment and wage situation, it only applied to wage orders. So, and it didn't apply to workers' comp. So here we have someone can be classified as an employee under a wage order issue, but they wouldn't get workers' comp, and they could be considered an independent contractor for the employee. So this is weird and not very good because it could be very confusing. So they carved out workers' comp. I don't know if it was just wage and hour, or might have Dynamex applied to other areas of employment law.
Well, the cases that came after that, and although the court, as usual, the Supreme Court was not clear how limited it was. Cases after it said, hey, it seemed pretty clear, and the issues before the court were about the IWC orders. Yeah. So the question of, hey, does it go out to workers' comp? The answer seemed to be absolutely not. The other question that wasn't answered was, okay, so is this, going forward? Is this going to apply to employees, workers going forward, or does this apply retroactively? Which is a big question we'll get into, but it could, what that means is, do we go back 3 or 4 years of potential violations because of Dynamex and misclassification of workers?
Okay, so then came Assembly Bill 5, and that's when the legislature looked at the situation and said, you know what? We are under Governor Newsom. We are predominantly Democratic. We are liberally oriented and in favor of workers, and we are now going to codify Dynamex, right? We're going to say, we're going to make it a law. It's not just a Supreme Court decision. And the governor said the purpose is to help reduce worker misclassifications, prevent workers from wrongly being classified as independent contractors. And it was stated that the misclassification of these workers as independent contractors have been a significant factors in erosion of the middle class and the rise of income inequality. So this is the philosophy behind codifying it.
And this had been, there's no doubt, the philosophy beforehand, but Dynamex left the door open for AB5. And there had been legislation that had been attempted before, but with Dynamex out there, it was their opportunity, and they struck to do this AB5 bill, which I'm not even going to try and be on the fence. It is a serious overreach of the law and changes the economy, the platforms for many, many businesses and for workers and their ability to choose in California.
You don't like it?
Did you get that from my statement? Yeah, I thought I was being subtle.
You believe in freedom of the individual to choose how they want to make arrangements economically.
Yeah. And so do they. That's where a lot of these pending court cases come from. They're from trucking associations and people who own their own trucks and have vested their lives in choosing to be an independent contractor.
They're the modern day cowboys.
Yep.
So anyway, the law goes into effect on January 1st, but defines who's an employee for purposes of workers' comp effective July 1st, 2020. So we're talking about that before, I mean, that because I was envisioning a world in which all these independent contractors became employees or were stated to have always been employees, and thus if they had an injury, it would now be filed as workers' comp, and we'd see this huge rush of workers' comp cases. Now there'll be many, many more employees going forward, which would increase the workers' comp cases. But since it doesn't apply retroactively, I guess the Borrello test would still apply before July 1st, and so we won't see this retroactive rush of all injuries into the workers' comp system. And it gives the employers until July 1st to provide workers' comp coverage for the employees. So we have some time. So if you're an employer, you got to think about this classification of your employees and getting your staff together when it comes to getting the insurance that you need. But the bill doesn't doesn't permit an employer to reclassify an individual who was an employee on January 1st, 2019 to independent contractor due to its enactment, which is stupid. I mean, no one's going to do that. And everyone's say, okay, you're an independent contractor even though you're an employee before July 1st, in which case you're back to being an employee.
Right.
And I just wanted to make sure that no one tried to do that stupid thing.
And even if somebody did do that, all they have to show is that it wasn't because of the enactment, it's because of the relationship had changed in some manner.
Now, what's the difference between AB5 and Dynamex? Well, generally it expands it. It applies the ABC test for all purposes, not just wage order claims. And then maybe you can speak a little more to what that means in terms of scope. Does that mean like if someone files a claim for harassment or sex or race discrimination?
It applies to every part of the labor code, which means every complaint of discrimination, harassment, those issues would fall under the employee status would be determined by the ABC test, where, before it was, again, Borrello. So there is no, except exemptions that we're going to talk about, there's really no safe harbor other than those.
So this is more than just wage orders. I mean, this expanded Dynamex. It made it the law of the land across the board.
It did.
But it also softened the effects of Dynamex because all the lobbyists descended upon Sacramento. They all descended in just droves. This was a great day for the lobbyists. And so they created all kinds of exceptions, and we're going to run through them. And we're going to talk about it, but it's still just a knife fight to adding exceptions with more legislations before July. So in the cases where people are accepted, then they are governed by Borrello rather than Dynamex. So let's just run through it. So here's some exceptions by one labor code: insurance agent, a doctor, an individual who has an active license from the state of California and is practicing as a lawyer, architect, engineer, investigator, or accountant. These are all exceptions. Okay, maybe that means my independent contractor can be back in independent contractor status.
Remember what we just talked about? You can't change it.
But it's an exception.
Which one?
It's lawyer. That's number 3.
Oh, well, lawyers would be an exemption.
So I can make him an independent contractor.
Yep.
I can? I'm going to do that because I'm going back to employee after.
Well, you still have to use Borrello.
Oh, I have to do that.
Yeah. Okay.
I mean, it's so ambiguous.
Not a lie.
See, this is the kind of stuff they were talking about.
Yep.
The Supreme Court was talking about. Anyway, securities broker, direct sales salesperson. That's an interesting one because there's a lot of salespersons that would want to be considered employees if they got hurt. Commercial fisherman on a vessel. And then there's a separate labor code that says Dynamex does not apply to professional services if all of the following factors are satisfied. So they're taking the white collars, right? And they're saying we're going to make a different standard for the white collars. Now, workers' comp, we don't have much of a white collar claim
exception. Yep.
Yeah, we just don't have many white collar claims. Like they make too much money, right? They happen, but for the rest of the world in the employment law land, this is a real shift because they're taking away Dynamex for professional services generally. And these are the 6 things. The person has to maintain a business location, so they got to have an office or something like an office. It could include a home office, so that's a pretty easy one. If the work is performed more than 6 months, they have a business license in addition to any required professional licenses. So if they're working at it for more than 6 months and they have a business license, if the individual has ability to set or negotiate their own rates, right? They're not told what their wage is.
Correct.
They can negotiate it. Outside of project completion dates and reasonable business hours, the individual has the ability to set their own time, their own schedule. So set their own schedule, set their own rates. They're customarily engaged in the same time of work performed under the contract with another hiring entity or holds themselves out to potential customers. So if they're out there in the world saying, hey, this is what I do, anybody can hire me, and it's not just you, the employer. And finally, if the individual customarily and regularly exercises discretion and independent judgment in the form for control, right? It's basically, if you have your own business and it's professional and you exercise control and the ability to negotiate and you have an office, and then you can say, hey, I'm not an employee, and the employer can make that deal with them.
That's right.
That's a pretty big, I mean, there's a lot of things. You have to meet all of these, like all of them.
Oh,
So that's a lot, but it is a significant carve out, I'd say.
it is.
And well, I'm sure the law is going to develop this for decades.
Well, yeah, I mean, again, we're going to be, this is the law as it is now, but there are many bills currently pending that could shift this. One of them being for example, small businesses. Small businesses are going to be one of the big ones that are impacted by this AB5 law. So what's been proposed is it's called AB 1925, and it would exempt small businesses as one of these exemptions.
Okay.
If you have 100 or fewer employees, make less than 15 million in gross, then AB5 does not apply to you. Umbrella still would, but AB5 wouldn't.
Okay.
Is that law yet? No, but it's one of the many ones out there that would make a big impact on AB5 and its ramifications for California.
Well, like I said, it's bloody up there in Sacramento. It's going to be for some time.
It's not going to stop.
Do you want some more exceptions? I got more.
Give me more.
I'll give you more.
Give me more.
So the statute specifies that professional services may include the following if specified conditions are met. So what is professional services, right? In this exception?
Right. And they give examples.
We got 11 of them, which I'm not going to read, but it's on your slides. There's another labor code that says that Dynamex doesn't apply to real estate licensees, right? Because the real estate agents, you see them, they could be employees where they go with their arrangements.
Well, they would probably be under an ABC test were it not for this exemption.
Yeah, and the repo man. The repo man is accepted, right? Which is good because I saw the movie. It looks very violent. Yeah. If he or she is free from the control and direction of the hiring person, right? So that's the exceptions. There's another one, doesn't apply to the following provided that specified conditions are met, a bona fide business-to-business contracting relationship. See, these are all different exceptions. I mean, there's just this ton of them, right?
Which is the result, as like you said, the lobbyists trying to carve these out to get AB5 passed.
Yeah, and it makes sense. I mean, there's reasons behind these, right? So bona fide business-to-business contracting relationship, a contractor is subcontractor in the construction industry. The relationship between the referral agency and a service provider, or an individual performing services to a contract between the motor club, and a third party. Is that like AAA?
Yeah, it would be
it's
like
AAA. A business.
Yeah, one of the big lobbyists as well.
Yeah. So like this is a law for one business.
Yep.
Wow. A motor club and a third party to provide motor club services. So as long as these could be accepted too. Another point, injunctive relief for misclassification of workers. Well, why don't you speak to this one?
Yeah. So the bite that they wanted to have with AB5, they knew that there was going to be kickback. They knew that there were going to be large organizations, especially in the gig economy like Uber and Lyft, who as of now have not and will not change their model. They're spending nearly $100 million in battling this in current cases and lobbying efforts. And I'll talk about some of the bills as a result of their fight that we're going to be seeing. But one of the bites that they wanted to put on this was for the Attorney General to be able to step in and impose injunctive relief for these types of situations, which may be one of the attempts by the state Attorney General to get them to comply.
So it's not just, hey, I can file a lawsuit and the employer can just wait it out to the lawsuit and the appeal. They can go in and say, you're classifying it this way now.
Currently, yep.
Yeah.
It's injunctive relief, and you don't have to wait for the year and a half for the battle to rage on. As of now, you are enjoined from classifying these people as independent contractors.
So they can do that.
They can. They have not yet, but this codifies one of their abilities to do that.
Okay. And then we have the truck driver exemption. That's a big one.
So the Truck Driving Association has started to pave the way for us to perhaps get out of AB5 to at least some degree. Now, what they did was they filed against the state of California saying, hey, we cannot and should not have to comply with this ABC test, because the B prong of working in the same industry as the person who's providing the work, the employer, is an impossible standard to meet. And by the way, this is covered by the Federal Aviation Administration Authorization Act, which really sets forth the rules for interstate commerce and pricing and routes. And this is going to directly, this B prong is directly going to impact that federal regulation. Because of that, it's preempted, which means it cannot apply federal law controls. So a federal judge in our California Southern District in federal court said, hey, it looks like you're going to win this case. This makes sense to me. So on New Year's Eve, before the AB5 rule came into effect, the judge said, I'm going to do a temporary injunction. And this does not apply to these motor carriers, these independent truck owners at this time.
Well, that's pretty huge. That's a whole nother dimension of defense.
It's massive. So in mid-January, the judge said, hey, you did some briefing on it. I know everybody's ticked, but it really does look like you're going to win on this. So I'm going to make this a full injunction, and you have to wait till the end of the case. And it is currently pending. Now, there's interveners trying to get involved here, asking for the Ninth Circuit, which would be above this Southern District federal court, to make a ruling on this, to say, hey, no, you cannot do this injunction at this point. The rule needs to stay in place if this is not a preemption issue. That's still pending. But as of now, truck drivers are exempt from the ABC test, and they're not going to likely make a change.
What implications does this have for other industries?
Well, it paves a way of finding these there's federal laws that cover employers in all sorts of aspects. Is there likely for most employers going to find a federal preemption issue like the motor carrier preemption? No, but it's going to start creating case law and starting to hit links into the ABC test and why it's impractical in its application.
Oh my God, Sullivan on Comp Chapter 4 is going to have been 2 inches thick.
So it's true. This is where it starts, but they're not the only ones. Uber and Lyft and DoorDash also have requests to the state Supreme Court on putting this rule on hold pending certain court cases. So the battle in court is waging on. Okay, existing law on misclassification. So right now there are already these laws out there that told employers, hey, you cannot willfully, if you know that these workers are supposed to be employees, you don't get to circumvent it. You don't get to say, hey, nobody's going to find out. They really want to be independent contractors. They said so in a contractual agreement. They signed right there. It doesn't matter at the end of the day. And if it's determined that the employer knew or should have known that these people were misclassified, then there's civil penalties and violations that go with that, just for knowing it.
You never could contract your way out of this legal standard.
No, and it amazes me that still, even today, I get the response from employers saying, well, they want to be independent contractors. We have an agreement.
It shouldn't amaze you. Employers are trying to do their thing.
I know.
You're doing your workers' comp. Your employment law. I'm doing workers' comp. They don't care.
They don't care.
Yeah.
And
they don't know.
They say, Eric, that I have that contract. That's going to help me, right? I'm like, well, no, not so much. So, but that's been the law for a long time. But I think these implications are even more so now because we have such a strict standard with the ABC test. With Borrello, there was a lot of arguments that, hey, we shouldn't have known because it's so confusing. There are so many factors, and we balanced it, and it didn't make sense. ABC, you either pass it or you fail it. So this is going to have more bite to it.
Okay.
So it's not just, so up here, I'm not going to go through all of it, but there's monetary penalties for doing it as well. Now, the reality is, and as it's up there, between $5,000 and $15,000 or
for each violation.
Per violation, which means per employee misclassified.
Yeah, for a big company, that could be.
It could be very big.
Yeah.
If you have, one or two independent contractors, not as much, and the the risk is more with the lawsuit itself. The lawsuit itself is going to be much more than 25K.
Yeah.
But it's another 25K to tack on to violations, which is significant. And by the way, these, even if you have what we call EPLI insurance, employment practices and liability insurance, which would normally cover things like discrimination or harassment, those types of things, it will not cover. And typically you cannot get coverage for misclassifying workers or these types of PAGA, class action wage and hour claims. And that comes directly out of the employer's pocket.
That insurance is so expensive anyway.
It is.
Often exceeds the real reasonable perspective. Well, of course, that's what they need to make a margin,
Yep.
but it's ridiculous how much that stuff costs.
Right. And I mean, until you get, a couple of big EPLI cases.
Yeah.
But I mean, if you're doing everything right, it makes sense not to.
But in California, it's impossible to do everything right. Isn't it?
You're allergic to God's ears. That's absolutely true, which is why you need us. So, I mean, these are the penalties. They're available. Are they going? It's another issue that's going to be implemented more than it used to be.
Well, in the pattern and practice violations, if they show you a pattern and practice is 10 to 25 grand, I wonder, can your license be at risk? Your business license or professional license?
Yeah, absolutely. Absolutely.
I don't know. Okay.
Okay. Additional penalties. Going through what happens if you actually misclassify employers. You have to do these postings now. So what's the Labor Commission is gearing up for is taking it on themselves to go after violators. And if you have violated just one misclassification of an independent contractor, now you have to post with all of these notice requirements for the public that you are a dirty, rotten violator. And
wow, you have to go knock door to door and say I'm a
well, not quite like that, but I know where you're going with that, but no. But you have to post, and all of your customers see it. It's out there. All of your employees see it. So could they have done this before? Yes. Are they going to be doing it now? In reality, more so. They are geared up to do it, and they will.
It's gonna be like shame, ding, 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 shame, ding, 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 ding.
It is, and they're going to use that tool because they know that the fight back on AB5 is real.
It's embarrassment.
Yep.
Okay.
So
Wait, you're gonna give advice to misclassify workers here?
Yeah. So, and where the carve out is, and this doesn't apply to an attorney advising their client, and it doesn't apply to if somebody is working in the organization talking amongst themselves about misclassifying. What happens is when other organizations advising a company or advising an employer, hey, I know what AB5 says, but go ahead and classify them. Nothing's going to happen to you. Now that person is separately and independently liable and can be separately sued for giving that type of advice. And does that happen that much? I mean, astoundingly, it does. There's a lot of people advising employers on that are not attorneys because of the fiscal implications of reclassifying everybody.
I see.
So now they're exposed as well. Okay. Well,
so what's gonna happen?
Yeah,
what's gonna happen?
You know what? I wish I could say for sure. My hope is it's repealed, but that's just me. The reality is we're going to be fighting about this for years to come. Currently, there is a bill that is set, and I believe it's 1928, which is set to be heard somewhere in mid-February. That's going to say, hey, we're going to be repealing AB5. We need to go back, start from scratch, and redo this because it doesn't have its implications are too far-reaching. It's an overreach, and they've even put in mid-January another bill that's basically blank that says, hey, we need to work on this. It's Bill 1850. We don't know what to do with it, but for now it's a blank bill, and we're going to start working on it.
So who's behind this?
Republican assembly people out there that are pushing these bills, and they have a lot of support, not just from the employers in California, but also the workers, the independent contractors that don't want to be classified as employees. It's people, and if you go and you ask somebody who is a Lyft driver, an Uber driver, which I do frequently to kind of poll, and not that this is a fair polling, but most people don't want to be controlled. They don't want to be employees.
Right.
They're students. They have other jobs. They don't want to report at 8 a.m. To every day for something. They like to be able to turn off the button and go do their shopping.
Yeah.
So their rights, their judgment, their choice is taken away.
But the government needs to protect them.
Right. But they don't want to be protected. Well, and this is the thing, and this is where the constitutional argument comes from. They have their right to choose, how they operate, how they work. If they want to be an independent contractor, has artfully been taken away.
Yeah.
It has been taken away. You don't get to choose that Lyft driver. You are an employee, whether you like it or not. Now you have to, your employer requires you to be on time. You need to be there, or you get fired.
I understand the perspective. What I'm wondering, is there any data? Like, is there any polls, or, is there any empirical evidence as to whether workers want this or not, generally? Well, I mean, probably some do, some don't.
Yeah, the stats that go out there are typically all, one-sided. So are they accurate? No. But is it a real concern? Yeah. I mean, the reality is people do want to choose. Look at the truckers and the trucking association that represents them.
But how are they going to pass this? They passed a law repealing it. They just passed it, putting it in, right? So why do they think they have any shot at
is the repeal going to happen? Likely no.
Yeah.
It's not. Are modifications to AB 5 going to happen? I think that has to be the case if it's not with more exemptions that go out there. I think probably the ABC test, the test itself, will probably be intact, but the exemptions will continue.
Expand and expand and expand. It's gonna be like the going and coming rule.
Yep.
They swallow up the rule. Yeah, and then it seems ripe for a lot of special interests. I noticed too that they budgeted 1.82 million for 15 workers' comp judges, and that's a lot. I don't know how many there are, but I think there's like 150. And I got, that is obviously an anticipation of increased workers' comp litigation. So, I asked you before, does this apply retroactively? We talked about this before and a little bit, earlier in this talk, but I mean, Dynamex itself didn't say.
It didn't. It left it open.
Whether the ABC test was retroactive or. But it's a big deal, because here's my vision is like I was saying, all these independent contractors become employees, and they say, 3 years ago when I hurt myself, that's actually was a workers' comp claim.
And I was an employee.
Then bam, there's like this huge wave of workers' comp liability.
Right.
And then who knows what that would do to their civil suit that they filed and settled or didn't settle, and it's progressing. So there's subrogation issues and retroactivity issues. And
it's still an unanswered question. So Dynamex didn't answer it. There were cases after that tried to. The Ninth Circuit, for example, answered the case in the sense that it said, yeah, it's retroactive. And the pushback from it, the Ninth Circuit usually doesn't get involved in state law issues, and realized the big pushback and depublished their case. But they asked the state Supreme Court, hey, you really need to answer this retroactivity issue. And it's still pending. So we do not know as of today, because the Supreme Court hasn't answered the question, whether Dynamex is retroactive. Now, the reality is, if you look in depth into the analysis of Dynamex, it was pretty clear that what the court was saying is, hey, this has kind of always been the case. We're making this clearer for you, but this has always been the case. If you look at the 11 balancing factors for Borrello, that they're compiled into the ABC test. It's just I
hate it when courts do that. When they try to pretend they're not reversing court by twisting the language of the prior decision. It is a change in course. It's not always been this way.
Yeah, but they and like you said, they didn't want to make it sound like they were completely changing their opinion. They're saying, this was always it, but you guys weren't getting it. So we're going to make it really clear for you. Okay. And that's where, so the likelihood in the analysis of Dynamex is it's going to be retroactive.
Well, then we should be afraid of a bunch of prior workers' comp claims from people who were previously considered independent contractors.
I think there's arguments out there that, fortunately,
what's the impact of AB5 on this? Did this speak to?
So AB5 did answer the question. Well, not terribly clearly, but they did answer the retroactivity question, saying, hey, for the purposes of AB5, this is prospective, not retroactive.
Right.
So they're making this
effective July 1st.
Effective for workers' comp July 1st, effective for everything else January 1st. So this is a prospective, not backwards looking, except for the exemptions that they put in there. The exemptions, which would favor for independent contractor, are retroactive. Right. So those exemptions are deemed to have always been there. Now. So it probably doesn't have the retroactivity, probably because in Dynamex it's been shown in other cases that it only applies to IWC orders. Dynamex probably, if it's deemed to be retroactive, won't have this far-reaching hit on workers' comp with more cases because Dynamex is so narrowly construed.
Right. Yeah, because it was just on that.
But AB5, they gave until July 1st, so likely we're probably in a safe harbor for retroactivity and workers' comp.
Yeah, that makes sense. And then since AB5 said the exceptions apply retroactively, that means those wage and hour cases, those exceptions might apply.
The exemptions might apply and they might be applicable. I haven't seen any cases that really apply that yet.
Yeah,
but they could.
Yep. Right. Okay. So let's sum it up. The Dynamex says it's retroactive, but it only applies to wage and hour.
Well, Dynamex did not say it's if you look at the analysis,
it implies that
it is. Yeah. It didn't answer the question. It's now the Supreme Court, the same Supreme Court, is asked by the Ninth Circuit to answer it.
Okay. So Dynamex purports or implies that it's retroactive, but it only applies to wage and hour, so workers' comp doesn't have to really worry about that. They're still under Borrello.
Right.
Although it could be implied that since they were just clarifying Borrello, Dynamex would apply.
I haven't seen that argument, but that argument could be out there. So there's always that exposure.
And then, but under AB5, the workers' comp changes are July 1st.
Correct.
Right. And
the
exceptions to AB5 apply retroactively, which only means that they might have influence on the wage and hour claims that would rise under Dynamex.
Correct.
It's a mess, isn't it?
It's going to get messier.
Yeah, as I see as a lawyer, I'm always looking for issues, and I see what issues are coming. And this thing is about 87 issues screaming at me.
Yep.
Yeah, so it's going to be a mess for a long time. And so the AB5 battle rages on. What are Uber and Lyft and those types of companies going to do?
They're standing their ground. They're currently doing it. They have not changed. They will not change. This will until the Supreme Court makes them change. And so right now they're making constitutional arguments that this is a taking from their business model, that this is a far-reaching impact. It'll basically close their doors because they're not going to be able to find people that want to be employees. It's going to affect not only Uber and Lyft, the company, it's going to affect the people who want to be an independent contractor. It's going to affect the consumer.
Why couldn't they get themselves an exception?
You would think with their money that they could have, but they didn't. But because this battle started because of Uber and Lyft. I mean, it was aimed at them. They were the target.
Right.
And they're the ones that aren't even complying with it right now. Everybody else is suffering because of it. But they were, for the legislature, the target, this gig economy for
they're the party poopers.
Huh?
They're the party poopers.
They are, they are the guilty.
So the reason they couldn't get an exception is because the legislature wouldn't give it to them.
No.
They're like, we don't care how many lobbyists you have.
Yep.
We don't like what you're doing, right? So we're going to not give you an exception. So that means that they're going to simultaneously lobby the legislature and trying to get that attitude
which they are, which is where these other bills are coming from that are pending. The one to repeal, the one to revise, all of these different bills out there are as a result of big money from these gig economy companies. They're jointly Lyft, Uber, and DoorDash that are spending tons of money on this.
So if they have that blank bill,
yep,
that would repeal it. And then they also have a constitutional argument, right? Which is what?
Essentially, it's a taking. They're taking away the right to choose. California, the legislature, you're deciding that there can't be really any independent contractors in California anymore, even though that's not the law of the land in any other state. California, you're deciding this for us.
Okay, well, we have enough time for some questions. I got one that I thought was pretty good. If for work comp JPA, or I guess would you hire a temp claims adjuster from a temp agency, or would you consider your employee? What about temps generally?
So generally with temps, there's the staffing agency that sends them, and the argument, and actually I'm glad you brought this up because we haven't gotten to it yet, is are you joint employers? Are you joint employers for that purpose? And the analysis typically is you are under even Borrello for the most part, and it goes into control and are they just working for you? Are they always there? And it just has to be a week and they're an employee.
What about the special general employer? But like if temp agency says they're my employee and I'm lending them to you as a special employee, these are temps. That's okay, right?
They can say that, but if this employee of the temp agency sues, and what we see a lot of is they sue the company they're being leased out to as also a joint employer. So the question now is, okay, so for joint employment, now does Dynamex apply to the analysis of joint employment, which would make a lot more people joint employers? And there were cases earlier in the year that said, no, this is not a joint employer issue. The old rules apply, which was great. Now we have a case that is that's pending on other issues that has asked the Supreme Court, that's pending before the Supreme Court, to answer the question, hey, does this also apply to joint employment and franchisees, the McDonald's out there?
Oh my gosh.
So, and there were cases earlier in the year that were just appellate level that said no. And now at Supreme Court level, now that question is pending. And if this goes to joint employment and franchise issues, the ramification, and it's retroactive, the implications are massive.
I've got a whole bunch of other questions here, but we're down to the last couple of minutes.
If you need answers to these questions, and I haven't had a chance to take a look at them yet, feel free to reach out to us directly. You have our contact info, and I'm happy, and it's up there. I'm happy to answer any of these questions offline. Either send them to me by email or give us a call. And we will be, because this is a moving target, updating and follow us on LinkedIn, because I'll post there for our blog if there are changes, and there will be. So stay tuned.
It's gonna be a wild ride, and
buckle up.
Yeah, here we go. But on behalf of Eric and myself, I want to thank you for tuning in and listening. Like Eric said, we have our information here with any questions or comments. We appreciate any feedback. It's always a pleasure to do these things. It's an interesting time, and we'll look forward to working with you on it.
Thank you, everyone.